Okay, everybody. Scott Sternberg here, Sternberg, Naccari, and White. Very excited to be back for our Wednesday Webchat series. Got my partners Mirvad Al-Jahari and Abid Hussein here to talk about, first we're going to talk about estate planning and business succession, particularly after COVID and how important that is. And then at the end, Abid's going to give us a little update on the PPP and what's going on with that. So Merv and Abid, y'all take it away.
Hey guys, so we've been receiving a lot of questions lately, regarding how our clients can help their families on a personal level. We've had a lot of discussions on how we could help them financially and with all their businesses after COVID. But on a personal level, it seems that a lot of people are having concerns, with family members going into the hospital, family members becoming sick, how they're able to maneuver, the medical systems and manage their estates properly. So, we've kind of been trying to set up foundational documents for them to help them navigate those situations. So, when we talk about estate planning, we're really talking about how you're going to transfer your assets at the time of death in a way that you want, not in a way that the state would dictate. We also cover your power of attorney. So we'll do your medical power of attorneys and financial power of attorneys, which really kind of help in the event of disability. And this has really been a hot spot during COVID because, family members are going in, nobody has the authority to make those decisions because they don't have the proper documents in place. So, again, it's really been a source of tension for people that don't have that planning in place.
Merv, what's been a really difficult situation that you've dealt with over COVID when a family member can't make a decision and somebody's in trouble? Let's say they've gone in the hospital for some sort of COVID-related injury even, or COVID-related treatment.
So what's been happening a lot with COVID is that people are going into the hospital, and because they're not allowed visitors, there's no communication with the family. So they go into the hospital, nobody can come in and visit, nobody can come in and discuss what kind of treatment is necessary. And the only way that you have the authority, even if you can't go in, is to discuss this with a doctor, is if you have your medical power of attorney in place. And a lot of people just don't have that kind of documentation set up. And especially now, not being able to communicate directly with family members, it's just become very important. And that's happening all the time.
I'm so curious about what happens with people that are having babies right now, and what happens if there's pregnancy related complications, and are you allowed to even be in the room? It's such a
they're not even letting husbands go in at this point to go visit when there's checkups. They're trying to limit a lot of in and out just to limit the spread of the virus. But again, that's where your estate planning documents come in handy, because God forbid something happen. Your will is going to list out who the tutor would be for your child if there needed to be. You have your living will that kind of dictates what would happen to you in the event that you were in a comatose state, not able to return, something that you would be able to mark yourself and kind of relieve that burden from your family. So all of these different things have come into play on a personal level. Like I said, tutorship and guardianship as well. So.
And let's also talk about some of the things I've experienced in my practice too, that a lot of times when people have minor children, we really need to think about what happens if something happens to both parents in some sort of catastrophic event. And, I always advise my clients to say the last thing you want to do is have all of your lifetime's net worth drop into the hands of a 16-year-old or an 18-year-old that's wiped out momentarily, right? So what are some of the things that you do? I know that I talk a lot about testamentary trusts and whatnot with clients. What are some of the things that you do?
Testamentary trust is a really good way to protect against that. So, the great thing about a testamentary trust is it doesn't come into existence until death. So you're not having to transfer any title to your assets while living and lose control that way. But, you're able to transfer the assets into a vehicle basically that protects it for the benefit of your kids until they get to a certain age. So that way they're not 18 years old coming into, a couple $100,000. A lot of people think that if you're going to use a testamentary trust, you have to have a lot of wealth, and that's the only way that it makes sense. But really, it makes sense if you have young children and you're concerned about that wealth being transferred too soon.
Or even young adults for that matter, right?
Right.
It's the idea that somebody who's, 18 or even, the way I sometimes set it up is I don't even have, I have triggers set up so that that payouts don't happen until they're a little bit older, maybe in their mid-20s and whatnot, so that they've got a trustee to take care of their college expenses and whatnot, and then they get a payout once they get out of college. A little bit more maturity, right?
Yeah, and you can add those types of triggers and kind of tailor it to what's important to you and what you think that wealth should be used for. I think it also depends on the child. I mean, you just don't know how your child is going to be at 20. They could be
Right.
very mature for their age, or they could not be. So putting in a trust and having somebody manage that for them, it's just a way to safeguard that wealth for as long as possible. And then again, you at a certain point you can say, look, well, once my child reaches this age, I'd like for them to be in control of the wealth themselves.
So let's switch gears to, say, business succession
Mm-hmm.
and what happens in the same kind of event. And let's talk through maybe somebody who's like a single member business owner. If they pass away and they haven't thought about what ends up happening to their business, have you experienced anything like that in your
Yeah.
practice?
Yeah, of course. So that's also a big source of tension there, because a lot of times if you have a business interest and you have, let's just say, a partner, that business interest, and you don't have estate planning documents in place, that business interest is going to transfer under Louisiana's intestacy laws. And that partner now may end up being partners with your children or other relatives of your family. And that's likely not their intent. So, if you don't take care of it in your estate planning documents, you can take care of it in other documents such as buy-sell agreements, things of that nature. But, you kind of have to think through those things, because a lot of people don't want to go into business with your family.
I'll tell you that I also experience there's a really interesting esoteric aspect of Louisiana law where if you're a single member business owner and you pass away, now as a result of Louisiana law, your heirs are assignees to the company,
Mm-hmm.
but there's no actual member of the company.
Right.
So the only way to really resolve that is to have some special provisions either in your operating agreement or in the actual articles filed with the Secretary of State, such that anybody who becomes like an immediate assignee also gets elevated to member status. And so those are things that I don't think very many people are thinking about at all. And it's so unique and specific to somebody who's a single member that owns a business. So stuff like that, it's very important to think about, right?
It's true, especially in Louisiana. We have in New Orleans, we have so many small businesses here and a lot of business owners, and it's, a day-to-day concern that you just kind of have to work through, make sure you have the proper steps taking place.
Yeah. So one of the things you mentioned was interesting because I think about this a lot in my practice, but there's two things that I wanted to talk about. One is a key man policy and the other is a buy-sell policy. So let's kind of talk through a couple of those. Key man policies are essentially policies for if a business has somebody who is so unique to the business that they are essentially the business. I've got a client who's a restaurant owner, but that person has gotten so much press because they are so unique in their knowledge of meats and curated meats that they are essentially the key man. If that person passed away, the business would no longer have real value. And so it's the idea that you get an insurance policy that pays out to the business or the business partners or whatnot in the event something happens to the key man, right?
Mm-hmm.
And then the second thing is a buy-sell policy. So I know you mentioned that. Do you want to speak about how you may have handled that?
Yeah, but so, buy-sell agreements between partners, it'll govern what happens to the deceased partner's interest upon death or other triggering events. So upon that partner being disabled, or if they, work a lower amount of hours, they're not able to come in, they're not, pulling their weight, all these different triggers you can put into your buy-sell agreement and say, look, well, upon these events, this is what's going to happen to your interest, so that it doesn't go into succession and then ultimately get transferred down to heirs as assignees or whatnot, and then create a big tangled mess. I mean, you can put in your buy-sell agreements how you want that transfer to occur. You can have policies that will buy out that interest so that it makes it easy on the heirs to go ahead and sell that interest. They get the cash, and the partner gets the operational side and doesn't have to worry about the heirs.
Mm-hmm.
I mean, there's all sorts of ways that you can tailor that to make it a lot easier on your family and on your partner. And I mean, a lot of businesses fail in the second generation for reasons like that. I mean, you have heirs that come in that don't really know the first thing about how to run the business.
Right.
And, they just know it was lucrative before and they think that they don't want to sell. So this kind of locks that down and makes sure, the transition happens smoothly.
Yeah, so those are some great points. I mean, the second generation of a business, a lot of times you got these people who are starting businesses and with the idea that they're going to take care of their family, but then something happens to them and then their family members have either no idea or no interest or no deep knowledge of the
Right.
business. And then they jump in thinking they can run it and they run it into the ground.
Exactly.
The buy-sell agreements are extremely important in those situations, especially when you have partners with you. There are also insurance policies in place that pay out in the event something happens to you, and so those buy sell policies are essentially life insurance policies on the partner, right? So
Right.
um,
And the partners each respectively can pay those premiums along the way just so that they have the liquidity to be able to buy those heirs out when the time comes. So
right.
just about planning and setting it up structurally so that it flows smoothly.
Right. Um, okay. Well, I think what we've done, we've talked about a lot of different issues. I think the big takeaway for all of this is that life happens and COVID happens, and so we would advise everybody watching this and every business owner to really think about what their needs are, and then think about what their needs, what they can't anticipate, and that's where we can really come in and help. Right. I mean, planning is key here.
Exactly.
And planning is not only important for estate planning, but it's also important for our PPP clients. And I know, Abid, you have an update for some of our clients. So Merv and I are going to shut our videos off and let you kind of take it from here.
Okay, sure. I am doing an update on behalf of our partner, Keith Naccari. He has been on top of the PPP issues from the beginning and is very much an expert on these issues. Unfortunately, he couldn't be here, but I'm going to do an update for him. We've got a great article on our website at SNW.LAW that discusses these updates. Essentially, it's now called the Paycheck Protection Flexibility Act. It was signed into law on June 5th by the president. And so I'm going to just cover the 5 areas in which things have changed for if anybody's taken a PPP loan. And for the most part, these are really, really good things for anybody who's taken a loan. So the first issue is that the maturity date has been extended to 5 years from 2 years. So the original maturity date was 2 years from the day that you got funded. It is now 5 years. And so for whatever amount is not forgiven, it will turn into an SBA loan, and that amount will have a maturity date of 5 years. The second issue is that the PPP covered period has been extended. So before, the covered period for PPP was February 15th through June 30th. It is now February 15th through December 31st. You can still elect to have it be an 8-week period, but if you don't do that, you're going to be covered under the longer period, which means that you're not turning in your forgiveness paperwork until after December 31st. So again, planning there is important to decide which period would work best for you, and you should definitely come talk to us about that. The third category is that the forgiveness determination can now include an impact by government agency proclamations of some kind. So for example, if your business was impacted as a result of you having to maintain local laws related to social distancing, if you're like a bar or a restaurant that could not have patrons because your municipality has said, or your local government has said you can't have people at a bar because of COVID related issues, then that's going to help impact your forgiveness determination. Now, again, where we are here right now is we don't know what those regulations are, and we don't know what the proof required is going to be. And so that's where I think we're still waiting on the SBA to provide regulations, and we expect those anytime now. But the law clearly allows for government factors to be included in the determination of what the forgiveness is going to be. The fourth issue is that there is now a lower percentage requirement for payroll. The previous requirement was you needed to spend at least 75% of your PPP money toward payroll. It is now 60%, with the remaining 40% to be spent on qualified expenses. And the fifth change is that the loan deferment has been extended. It has now been extended up to 10 months. And so you have a longer amount of time to defer the repayments of the loans. So that's the update. Again, we have a great article summarizing these issues on SNW.LAW. And that's it for me.
Well, thanks everybody for tuning in to the Wednesday web chat. As we move away from COVID and toward, hopefully a reopening scenario, we're going to keep these going because we know that there's important updates that we can share with you every Wednesday. Please check out SNW.LAW. We've got some really great content on there, and we'll be back next Wednesday at noon. Everybody, wash your hands. Be safe.